There are no additions or deletions to the agenda.
Next, I will open the public comment period of our regular meeting. Anybody wishing to speak on items not on our agenda, they may do so at this time. If you could please limit your comments to around 3 minutes, we'd appreciate it.
Is anybody else?
No, just you, Jan.
Okay, all right.
And please just state your name for the record. And
Thank you. Jan Hamilton, citizen of Pickens County for 15 years. And I'm here because of an executive order that was signed by our president in Washington on Monday, which states that any entity involving a federal contract can no longer discriminate against lesbians, gays, bisexual, and transgender people. And I think most of you are familiar with, I've given all of you this, and I'd just like to read what it says. The Human Rights Campaign envisions an America where all LGBT people are ensured equality and are embraced as full members of the American family at home, at work, and in every community. By placing this sticker where others can see it or giving it to a friend, you help to spread the message of equality for all. And you may have been aware that I was sent a flag like this, and it's now still on my car after the 4th of July parade because the kids down the block said, "We're proud of what you're doing. Could you please keep the flag flying?" So the federal entity that I would enlist your help with is the hate crimes law, Matthew Shepard and James Byrd, that was signed by the president in 2009. Number one, incident of hate motivated an actual or perceived race, color, religion, national origin, gender, sexual orientation, gender identity, or disability of the victim poses a serious national problem. 2, such violence disrupts the tranquility and safety of communities and is deeply divisive. 3, the state and local authorities are now and will continue to be responsible for prosecuting the overwhelming majority of violent crimes in the United States, including violent crimes motivated by bias. These authorities can carry out their responsibilities more effectively with greater federal assistance. Number 4, existing federal law is inadequate to address this problem. Number 5, the prominent characteristic of a violent crime motivated by bias is that it devastates not just the actual victim and the family and friends of the victim, but frequently savages the community sharing the traits that causes the victim to be selected. And number 6, it's the last, the offense is considered criminal and is therefore punishable with fines and prison sentences. And when I talked with John, he said he was a part of some of that in Wyoming before he moved to Aspen. The thing that I see happening in our community, and Rob has told me there's city and county jurisdictions, and I do respect that. I contend that as a part of the authority figures of you in our city and county, that city ordinance section 1504-570 be enforced, and that you would help us look at those federal contracts to see if there's any impact on Pickens County if we do have federal contracts. The definition of discrimination, I think we all know, but it does include sexual orientation. Aspen was the first city and county in Colorado to institute this city ordinance in 1977. And I was told that it has not, to this point in time, been enforced in any case. And yet, with the suicides and the murders and the deaths of people that have been known to be identified in the LGBT community, I just would like to enlist your help in investigating and implementing the protection that I believe is appropriate at this point in time. Those are covered, the discrimination in housing, public service or accommodations, or employment. And the public service accommodation is the one where I'm not allowed to go to the Aspen business luncheon today at the Mountain Chalet. When I was outed at the First Baptist Church as a lesbian. I was told by the owners of the Mountain Chalet that I'm banned from going there, and I have been banned for 6 years. And I continue to get invitations from Todd Schaefer, but I can't go. It says here, public service accommodations means any place of business engaged in any sales to the public and any place offering services, facilities, privileges, advantages, or accommodations to the public, which seems to fit. And then also, it's just about a page, and I won't read all that, but under, says D, discriminatory public services and accommodation practices are prohibited. It shall be unlawful for a person engaged in providing services or accommodations to the public to directly or indirectly discriminate against any other persons by refusing to allow the full and equal use and enjoyment of the goods, services, facilities, privileges, advantages, including accommodations and the services and conditions under which the same are made available or provided to, or provide adverse, unlawful, or unequal treatment to any person in connection therewith. And then the next 2 paragraphs involve penalties. If anybody violates this, they can be charged $300, they can spend 90 days in jail, and they can lose their license to do business. So I think my 3 minutes are up, and I have copies of this for each of you that I brought by yesterday, not realizing you had a meeting today, and when I checked on it, they said, well, they're about to have a meeting. So I just would humbly enlist your help as the documents come across your desk to examine them in light of these state, local, and national laws. Thank you very much.
Thank you.
I carry it with me everywhere.
Oh, good. I put your names on them yesterday because I didn't realize I'd see you.
Thanks, Tim.
There we go. Thank you.
We'll get a copy for the record as well.
Oh, I have another one in the car. I'll bring it back in.
No, we can give her John's.
We can
Don't
give her-
worry. Yeah, we'll have enough.
Okay.
Thank you. Anybody else wishing to make public comment at this time? I will close the public comment and bring it to commissioner comments.
I don't think I have any today.
George?
There was an interesting article in today's paper, beer activity picks up. I was actually riding on the Rio Grande Trail early this morning below Rock Bottom Ranch, and I saw two signs to alert people using that part of the trail that there's beer activity. And sure enough, as I went down a little further, I saw some beer scat. So for those using the trails, early morning or in the late afternoons, there is activity, and for those residents throughout the city especially, you need to keep your trash in beer-proof containers, and don't be baking cookies and with your windows open. It was a little ironic, I guess, or surprising that there were a couple citations already issued to some restaurants and some of the beer's favorite hangouts. One is the Hickory House. So anyway, it is beer season. Let's not have to put down any beers unnecessarily because we're not taking care of our own trash.
Thank you. Any other commissioner comments today?
Actually, I do have one. I'm sorry. We're not going to have another regular meeting until after the Saturday, August 2nd Wilderness celebration, the 50-year anniversary of the Wilderness Act. And the event is going to be held up at Aspen Highlands. I'd really like to encourage people to attend. It's kind of hard to imagine what our community would be like without the Maroon Bells Wilderness or some of the other surrounding wilderness, the Hunter Valley, Upper Hunter Valley, and to imagine that those lands would have potentially been available for Forest Service trade or sale could have really radically changed our community. So I think it's an important act, and I think that there are further lands that should be preserved. So let's all turn out and show our support if we can.
And I think, Rachel, because of our sponsorship, they got the price down to pay for everything down to $10 per person, and
In conjunction with the city's contribution, it's very affordable family-style event.
so it should be a fun event up at Highlands. Any other commissioner comments? Moving on to consent action items. We have the first item, which is the minutes of work session May 13th and July 1st, and regular meeting of July 9th. Any
Move to
comments or
approve.
motion? Got a motion from Rachel,
Second?
second from Steve. Any discussion? All those in favor say aye.
Aye.
Thank you. Next, we have a resolution improving environmental public health advocate, Kurt Dahl.
Kurt Dahl, Picking County Environmental Health Manager. I'm here today with Tom Dunlap, seeking your approval to reappoint Tom as the Environmental Public Health Advocate for a 3-year term. Tom has been serving as the Environmental Public Health Advocate since 2002, and he's been representing Picking County and other rural counties, really with environmental public health initiatives at the federal level. He's been working with the FDA, the National Environmental Health Association, the National Association of City and County Health Officials. And I know you've been teaching food safety classes too. I thought I'd let Tom briefly discuss what he's been doing in the last year, but what I've found is that Tom's involvement in these national initiatives has been really beneficial to my department. Keeps us up to date on things like the Food Safety Act, the Federal Food Safety Act, and some initiatives with oil and gas fracking that I know he is working on now. So I think it's been a huge benefit, and I'd like to continue to see him serve in this role. It offers his availability to serve in these roles. So with that, I think I'll turn it over to Tom.
Thanks. Tom Dunlap. It's important to recognize it's a non-paid function for those that aren't familiar with the title. I do represent Picking County and indirectly, I guess, the city of Aspen and many local small health departments in some of the associations I work with. The idea behind the creation of this position was when I retired as the environmental health director from Pitkin County in 2001, was to continue the exposure that we had been able to give Pitkin County and other small local health departments to national issues that do directly impact us. And Kurt just mentioned a couple of them. One is the fracking issue, which is big right now. The food safety, the Food Safety Modernization Act, which also affects local government and local consumers. So by my remaining involved with your appointment of me, it's, I think, been able to give a continuous voice to some of these national and regional issues and some state issues. At my last quarterly update with the board, I filled you in. I won't rehash any of those issues, but quite a few national and local issues that are being brought forward. One in particular is the Environmental Public Health Tracking Program, where we're still working on associating various forms of illness with environmental exposures and land use issues, water quality issues, air quality issues, and the association that might be made or that can be made or is being made through clinical studies of cancers, birth defects, various forms of cancers and asthma, childhood asthma in particular, just as an example. So I have been recently reappointed to work with the Centers for Disease Control by the National Environmental Health Association on the Food Safety Modernization Act for another 3-year term. I'm doing teaching, as Kurt mentioned, for the Food and Drug Administration, keeping in touch with all the latest federal inspection guidelines and so forth. And so I'm asking to be reappointed. It's up to you if you want me to continue. And what we are purposely trying to do is to have conversations, Kurt and I, and also when it's appropriate, which is many times, to show the linkage between the public health discipline and environmental health discipline, hence the title Environmental Public Health, to show how those are integrally linked in many different projects and public health issues. So we meet somewhat regularly, somewhat formally, sometimes informally. Conversations, or I'll stop and talk with Kurt or send an email to Liz, and also sending both Liz and C.J. Oliver and Kurt and Dr. Levin, our medical health officer, information that comes to me nationally that I think might be pertinent to their specific disciplines and what they do for the county and the city. So with all that, I'm certainly willing to take direction and questions from the board.
George?
Oh, I would just say, I just want to really thank you, Tom. Tom works just tirelessly, not only our behalf of residents of Pickens County, but for citizens around the country on these issues. And it's, you're hardly ever here because you're either at conferences around the country or teaching. So I really appreciate all your hard work and your efforts in addressing these issues. So I certainly would support
Thank you.
your reappointment.
Steve?
I would echo that sentiment. Your efforts are really greatly appreciated by us, and set a high bar for how someone can retire from one part of what they're doing in one part of their life and yet continue to make a great contribution to the community. And it just shows how a medium-sized county in Colorado can have an impact across the whole country, really, by having your presence at the different things you go to.
Thank you very much.
I certainly agree with all that's been said, and thank you, Tom.
Thank you.
I agree as well, and I almost think in the resolution where it says Tom is successfully represented, I almost think it should say Tom has tirelessly fought and represented us with these issues.
So amended.
So, as a kind of a pat on the back to helping us out in this volunteer position.
I would make a motion to approve the resolution approving our environmental public health advocate as amended, as Rob has suggested.
Second?
First and a second, any discussion? Seeing none, all those in favor say aye.
Aye.
Thank you very much.
Thank you.
Next on our agenda is a resolution appointing citizen board members. And the citizen board members under this resolution are Joe High for the Senior Service Council Regular Term 1 and David Siegel, Senior Service Council Alternate Term 1.
So moved.
Second.
We have a motion and a second. I'll just say, as I often do, or the chair often does during these appointments, that we, just like Tom, we've got a lot of, although Tom is an appointed position, specifically for the, to be our environmental public health advocate, the citizen board appointments are not taken lightly, and the people that serve spend many hours to the benefit of the county, and we appreciate their help in our decision making. Any further discussion? All those in favor say aye.
Aye. Do that in just a second.
Yep.
Go ahead.
Consent public hearing and application for a medical marijuana license conversion to retail marijuana cultivation facility. And Jeanette is here to present it, or and we have the packet in front of us as well.
This is
Go ahead.
an application by Silver Peak Apothecary for a conversion from a medical retail marijuana cultivation facility license to a retail. And if the board will remember, I believe it was on July 9th that there was an ordinance that came before you for your adoption of medical regulations, and as part of that there was a clause put, or an exemption in the ordinance that this process would be allowed. Jody Edwards is here today, and I think Hillary from, if you guys, you want to come up, or do you want to just
If you have any
hang there,
questions, we'd be
or-
happy to answer any questions. I don't think we really need to do a presentation unless you have some issues.
All the conditions have been met. They're the same conditions that were in place for the retail license, and the applicants went through a process to address all the conditions of approval, and there are no outstanding issues.
My understanding is you approved the medical license for this facility on March 4th, is that correct? And it's just a conversion of an existing license. It's already met all the 18 criteria. There'll be no physical changes, no new employees, no new plans.
Rachel?
Yeah, I just want to clarify, because I think there may be a typo in the memo. 1, 2, 3. The fourth paragraph states that the applicant appeared before the BOCC on March 4th with an application for a retail marijuana cultivation facility, which the BOCC granted.
Correct.
So the retail license has already been granted?
It's already, that you did grant a retail license.
For
There
cultivation?
was a medical license. The applicants hold 2 medical licenses right now that was approved by the manager, the administration,
Right.
prior to the clerk taking over as the licensing authority. So they want to convert one of those medical licenses to an additional retail license.
Okay, so they do hold a retail and a medical at the same location now?
Correct.
And so if we were to deny this, the existing retail applicant that was granted March 1st would still hold and still be viable? And this is just for the conversion of the second medical. Thanks for the clarification.
I'm still a little confused.
Yeah,
on
I'm
that,
confused.
actually. So the application is for conversion from medical grow site to a retail grow site.
If you remember,
We
when-
approved a renewal, or it was an administrative, that was approval for renewal of the medical license. I don't recall that we actually approved a conversion to a retail, and why would we approve a conversion to a retail and have the application come back for the same thing? I'm a little confused.
It's a medical license that they hold, or maybe John.
There's more than one license for the same facility. So originally, I believe there were 2 different optional grow site licenses for medical marijuana cultivation at this one location. And one of those was previously converted, so that allowed the cultivation of marijuana plants that would be used in some specified amount, one for medical, one for retail. So what this request is to convert the other medical cultivation license, or the optional grow premises grow license, into a retail marijuana cultivation license, so that the entire facility then becomes a facility cultivating for retail marijuana. Instead, right now, it's half and half, give or take.
And when does that expire?
I don't know when the licenses expire. Do you know?
February 2015.
So this would override that expiration, so then you would start the clock again.
Right,
If approved today, it would be valid for a year
right,
for a retail grow site.
correct.
Okay. Thank you.
I need a little clarification. Jeanette, you said that the licenses, the regulations that we passed, the most recent regulations, I'm assuming you're referring to, included an exemption specifically for this location?
You would call it an exemption, John, or there was a criterion there where there could be a conversion of a medical license to a retail license as long as it is approved by this board.
Calling out specifically this applicant?
No, it wasn't an exception or an exemption. It was simply an allowance that recognized that this type of application
This
could
kind
be,
of
could be
converted.
pursued. Right.
And not specifically to this
Right.
location. Okay, that's where I'm confused,
Right.
because the tricky thing that happens here is that since we've written those regulations, the Crystal River Caucus has weighed in additionally on wanting some moratoriums within their caucus area. Although we have not taken formal action within our regulations to add that retail aspect to the regulations, the caucus area has weighed in with a vote that took place on July 10th in favor of not allowing this type of application to come forward. So the conundrum now comes with the fact that we haven't actually written that into the regulations because the vote was taken after, since we've done any regulation modifications. But the intent was clear at the Crystal River Caucus. And I'm just making the board aware of that.
I don't think that's true. I don't think any of the moratoriums have said shut down existing businesses. They've said do not license new businesses. This is not a new business, and this is a conversion within an existing business.
Well, I would clarify, I would slightly beg to differ that the vote that was taken was to not allow any new licenses to be issued, and without the effect of it being an existing business or conversion or that sort, it is still a new license. Should new licenses be issued under retail, cultivation, manufacturing, testing, and the 4 different categories under retail, which were not previously voted on under the Crystal River Caucus. And George and Steve were both at that meeting as well, and they can reflect on what their thoughts were. Steve.
Yeah, if this were an application for a brand-new facility in the Crystal River, then in my mind, I would strongly consider the caucus vote that was taken. The fact that this is an existing operation, it's not going to get any bigger, it's just converting part of from, it'll be the same number of plants in the grow facility. The operation really won't change in any other respect. Also, the fact that at the Crystal River Caucus meeting, a neighbor in that subdivision, that a couple doors down from the grow operation, said that it was there for 2 years before she was even aware that the grow operation was there. It's been absolutely no impacts on their neighborhood and no problems associated with it whatsoever. And she spoke strongly in favor of allowing marijuana grow operations in the Crystal Valley. So, in my mind, I have no problem with approving this conversion now.
George? I have a question for staff. And, I see several staff here who would answer best from ComDev. When you issue a medical marijuana grow site versus a retail grow site, is there a difference in terms of where those sites can be allowed or how they're viewed? So in other words, are they viewed as a commercial operation or a residential cottage industry type of operation?
You know,
Because-
George, I know you're looking at me. Lance is our guy, and I think John is more up to speed on the specifics of what's allowed where with the grow versus the retail. But I'm pretty sure retail's only allowed in the retail zone districts.
Well, if you're talking about retail sale to the public versus retail grow,
No, I'm just talking
Okay.
about retail grow because it's a retail operation in an existing residential area.
There's no distinction between the two different types of cultivation, whether the product is used for medical purposes or retail purposes.
Okay.
Rachel?
Yeah, I'm also going to support the application for conversion, and just as a matter of simple logic, if we were to deny this application today, grows would continue there, except they would be only able to be sold to medical through medical outlet. So the denial of the application does not make the facility go away. They have an existing license. This is an application to convert. If they do not convert, they will continue to use their existing license to grow the medical marijuana. It's not a re-upping, it's not a renewal, it's a conversion application. So I don't see that it would make any physical difference of what is happening there.
So again, just to clarify, actually half of the facility is currently used for retail now.
Yes.
And the other half is for medical.
Yes.
I'm not sure if it's exactly half and half, but there is some
So
portion
some is
division.
currently being used for retail now, so that would continue regardless until that license expires.
Right.
So the question is whether we would allow the other portion that's medical just to retail it. And as much as I'm sort of opposed to retail grow sites in residential areas, here's a case that there already is an existing one. It's good for a year, and if there are any complaints that come forth to us or the staff, then we have a chance to revisit that when it comes time to renew.
Correct.
That's
And
all
just,
true.
just to kind of explain what I was trying to say before, or why I was trying to say it as well. First and foremost, for the record, I'm for approving this application. For all the reasons that have been stated, that it's an existing thing. But in the drafting of the regulations, I was the one that was a little bit hesitant to allow the caucuses full reign for a moratorium. The only reason why I agreed on that was that it had a limit of time, and that it wouldn't be the tail wagging the dog forever and ever, and that they're an advisory group to this board. They don't create code for their areas. We create that with their advice, and we heed their advice very well. But having been at that meeting, I just wanted to make it clear to the rest of the board that I felt like I made it very clear that the vote that they were taking would deny future licenses, would potentially deny the renewal of licenses before the end of that moratorium, and because we talked about that, and that it would effectively, if a license were in place and they were adding a new license or something, that they wouldn't be able to have that license. And that is what the caucus voted on, in my opinion. I thought that the explanation that I gave at the caucus was pretty clear to the people that were there and voted on it. But again, I will also say that I'm in favor of moving forward with this for the reasons that were stated, and I also think that the caucuses should be more of an advisory role than a policy-setting role. They're not elected officials. They're the people that show up on any given day to vote on something. So I just wanted to make that clear as in terms of why I was bringing that forward for information for the board. Steve?
I would move to approve the application for conversion of a medical marijuana license to a retail marijuana cultivation facility licensed by the Cooper Mason Ventures 2 LLC, doing business as Silver Peak Apothecary.
Second. Any discussion?
Public comment.
Oh, that's right, this is a public hearing. Anybody wishing to speak on this item may do so at this time. I'll open the public hearing. Lauren, come on up, just state your full name for the record.
Good afternoon. Lauren Mayton, for the record. I just really have one matter to correct from what I've heard today, and that was a statement I believe that Mr. Childs made, and that was that the operations between a medical and a retail being the same number of plants, I believe is what you were referring to, and I want you to be aware that that is absolutely not the case. The matter is that for medical, the number of plants is tied directly to the patients. So you can never have anything, and they're broken into tiers of how many plants you're allowed to have, or how many patients you're entitled to have based on your license, the type of license you own. You can have up to 300 patients, up to 500 patients, things like that. But the plant count is directly tied to those patients. Retail, recreational, zero ties to anything. You can grow as much as you'd like. And it's wholesale product, so it's not connected to anything. So I just wanted to, for clarification, for your edification, to know that that's the case. Thanks.
Thanks for the clarification.
Anybody else wishing to make public comment at this time? Seeing none, I will close the public comment, bring it back to the board. We've got a motion and a second. Any further discussion, Rachel?
Yeah, I'd just like to comment and kind of put a tickler for our future work sessions or further edification. After October 14th, the requirement in the state law for the vertical integration between grow facilities and sale at retail facilities to the public goes away. And currently there is a requirement that any retail operation also grow 70% of the product it sells. I think that will be a bit of a game changer in the landscape for whether there's applications trying to stay somewhat close to their retail location versus other areas within the entire state that may be more suitable, more affordable, more sunlight, you know, than in our little valleys. So I think that we as a board should, you know, really become aware of and watch and track those sort of changes as we continue to watch our own codes going forward. And then I also wanted to weigh in a bit on a comment that Rob kind of touched upon, that, you know, the role of caucuses and in the county. And I think that in assisting in planning their community and talking about what they would like in their immediate environment makes a lot of sense. And it's very valuable input, and it's more local knowledge. At the same time, we're all parts of a whole. We're all parts of an entire county. And I could see a scenario playing out in my mind where every caucus says, no, we never want any transferable development rights coming into our area. We won't mind sending them, but we don't want to land them. And, you know, we don't want any grow facilities, but 70% of our public voted for marijuana legalization. And, you know, where do those facilities go, and how do we work as an integrated economy and integrated local food production, integrated local sourcing? And so it's just getting to be where I've started to wonder, well, should we have a new advisory vote and ask some advisory questions this November on the codes we just passed? You know, is this what you guys really wanted? Is this not what you wanted? You know, but we've gone from a public vote with over 70% support in our county for legalization of marijuana to saying, well, not here and not here and not here. It's just, I don't, you know, maybe the public has changed their mind. Maybe now that they've seen it, there's a difference and the vote would turn out differently. But in other instances, clearly, we've had neighbors say, I didn't even know it was here for 2 years. And this has been operating for a goodly period of time, and we've not seen complaints. We have an application in front of us that did not have violations, did not have complaints. And so I would like to hope that the fear of the newness is starting to wane, and that we can move forward with all sorts of things. I mean, yesterday we kind of heard from as close to a caucus area as you can get to say, don't put this house at the apex, and yet we did as a board collectively. And so it's kind of like, when do you go against quota caucus or neighborhood interests, and when you don't? And is the expectation rising that there is fiefdoms within the county that control beyond the elected officials. And I think that it's very important to maintain the appropriate balance. And I'll just leave it there.
Well said. George?
I don't totally agree with that, but that's no big surprise. The neighbor who lived adjacent to this property for 2 years, actually 2 years ago, it was illegal to disclose where growth sites were by state law. Nobody knew where these sites were unless they were privy.
Well, the activity alerted them.
Well, you
And
can
it
see
didn't.
it. Anyway, to the credit of the Crystal Valley Caucus, they have probably spent more time on this issue than any other caucus that I know of. They've had multiple meetings. They had a panel at the last meeting, which consisted of 3 commissioners as well as the sheriff. The applicant was up there at a meeting prior to that. So they are probably the best informed caucus of this type of issue. And so I wanted to commend them on that. And I think it was very clear, even though it's a simple conversion, and I understand that, philosophically, they had a long discussion over a series of meetings, and the outcome was that they did not feel that it was appropriate for their neighborhood to have retail grow sites. Given that the county has, it's interesting, the vote in the county was about 70% in favor of legalization, but we don't see grow sites applications coming from within the city of Aspen. If we did, I think we would hear an outcry. The town of Snowmass Village does not allow any grow sites or any retail at this point. So one could interpret that 70% vote in many different ways. But given the amount of time that the Crystal Valley Caucus has spent on this, and I believe as well informed as they are, I'm going to support their recommendation and deny this application.
Rachel?
Yeah, and thanks for your comments, George, and I respect those, and it points out to me I need to clarify. My comments were more in general about the caucus system and certainly not specific to the Crystal River caucus alone. And I just think it's important to acknowledge that the county has tried in many ways to be of great assistance to the Crystal River Caucus in that area. I think the efforts that we're making and the additional expenditures to our legal department and otherwise on the Thompson Divide issue show huge support for that region. The work in Elk Park, the work, through the water fund to get rid of the potential dam and the water rights. And we went to battle and lawsuits with the Colorado River District for the Crystal River Caucus and Crystal River area. So there's a lot of respect and a lot of give and take in that area as well as the rest of the county. What I'm just trying to say is that at a point, we can't march as all individual islands and expect it to act as a county as a whole. And that's exactly what you were saying about what did that 70% vote mean, is why I said, we really should consider checking back in with the public when we already have a ballot and there's no extra cost, and ask some advisory ballot questions about what the public feels now that we've gotten to this point. So I just put that out there for everyone's consideration. I wouldn't mind having greater feedback myself.
Yeah, thank you.
And I'm going to vote in favor of this application, but I'm also going to explain why. I said it the other day in the Celestial hearing, which was, as you said, a similar thing with the neighbors not wanting something, but us not really finding anything wrong in the code. The code is there for a purpose. The code is there to protect our quality of life here. The code is there to protect the neighbors. And the code is there to protect the property owner for their property rights. And the code cannot get changed in a heartbeat, in a flash. And it's very specifically written in our Home Rule Charter that it can't get changed in a flash to protect those rights. And yes, the Crystal River Caucus has weighed in my opinion, to not want some new licenses in their area, but the code has not been changed to reflect that yet. And that takes P&Z, our approval, and moving forward. So it is at our discretion in this case, in my opinion. We have a first and a second. Any further discussion? All those in favor say aye.
Aye.
Oppose?
Nay.
Next is a emergency resolution set for confirmatory reading on August 13th, authorizing the BOCC to enter into an intergovernmental agreement with the USDA Forest Service White River National Forest. Ron Ryan is here,
Good afternoon.
not in uniform. Sorry. Sorry.
I look better in the green.
It's undercover today.
Well, I noticed that. Were those new shirts that you guys had the last time you were here?
New for me.
Yeah, with a little flash band and stuff.
Oh, yeah.
Yeah, fancy, nice.
I'm
Anyway,
bringing to you a resolution today for that agreement we have had with the Forest Service for many years previous. This allows us to do some of the remote patrol on behalf of the Forest Service as well as Pitkin County Sheriff. And on Forest Service roads, the campgrounds, and more remote areas of Pitkin County. In exchange for that, the Forest Service reimburses us. It changes each year how much it is based on how they're funding things. This year it's going to be, I think, $5,400 for that reimbursement. Previously, it comes to you as an emergency resolution because previously the sheriff has just signed this and it was brought to our attention. Since it is an intergovernmental agreement, that it's more appropriate to go before the board and be formally dealt with. So that's why it's an emergency resolution due to the time frame that the Forest Service has in getting this back to them.
any questions, George?
And Ryan, part of this IGA allows the Sheriff's Department through Mountain Rescue to go onto the Forest Service lands and have an arrangement to enable rescues to occur.
That is a different agreement relative to mechanized rescues. That's not dealt with in this particular agreement.
Steve?
I was looking at the list of roads that you have the ability to patrol for the U.S. Forest Service, and one of them is Capitol Creek, which is where I live. So I started wondering, do you actually patrol regularly on the Forest Service part, or is it more that only if there's a call for somebody who needs help in that area that you would go on, you know, like up Lincoln Creek Road or whatever?
It's both. We'll respond to the calls for service in the Forest Service area. We're also agreeing that when we're in the area, that we'll go a little bit farther than we would have normally for whatever sheriff task we happen to be on. And if we don't seem to be hitting some of these more remote areas, then we will assign deputies to go out there onto those roads so they get some kind of presence.
Okay.
Michael?
Ron, do you enforce federal law at that point?
No. It's primarily a presence for our citizens and our visitors in a law enforcement capacity. And if need be, if there was a federal issue, that we could basically freeze the situation until the Forest Service law enforcement officers arrived. Most of the things we deal with tend to be state issues anyway.
Rachel?
Do you have any, well, thank you for being here today, sorry. And then also, you know, to say I fully support this and appreciate and the role our sheriff's office play in public safety and reassurance and those sort of things. But I'm kind of wondering, just as we track and work on federal issues, how close do you think that reimbursement comes to the hours and time you spend with the public in these areas?
It falls very short to the actual time that we're spending.
Yeah.
But it still is within Pitkin County, and we want to be out there regardless. So getting any reimbursement is a benefit to us.
Yeah, and I'm fully agreement. I just think that I would request that we try to track that at some level. We're frequently involved with national discussions of Forest Service funding and the adequacy, and having the facts and figures to back that up when we make those presentations in DC is really helpful to let them know, because you're probably aware we receive about $1.3 million payment in lieu of taxes from the federal government, and yet that's always on the chopping block. It's not funded for next year right now. And to be able to say, hey, you know, we spend $100,000 in sheriff's time or whatever it is patrolling those Forest Service lands, that's why we need that payment in lieu of taxes. It's just valuable evidence for us.
We can do that.
Thank you.
Good thought, Rachel. Any other comments? Accept the motion.
I'll move to approve a resolution of the Board of the County Commissioners of Pitkin County authorizing the BOCC to enter into an intergovernmental agreement with the USDA Forest Service, White River National Forest.
Second. Any discussion? All those in favor say aye.
Aye.
Thank you. Next, consent action items, first reading set for public hearing on August 13th. First is a resolution approving a license agreement with the state of Colorado granting permission to cross Highway 82 access control line for the AABC pedestrian tunnel, which we better get in place because people have been walking under there for a while now. GR is here to present this item.
Thank you, Rob. I'm GR Fielding, the county engineer. I'm here for Brian Pettit today. He's out on vacation. This is one of a number of housekeeping items that we have for the administration of the project that we had installing the pedestrian tunnel under State Highway 82 at the Aspen Airport to the AABC. As it says, it's a basic license agreement in order to have that infrastructure in place. The board does have a little bit of experience with that access control line. It's something that we talked about fairly extensively during the access control plan that we went through from, I believe, is all of my tenure up until 2 years ago when we adopted it. This is in conjunction with a number of other agreements that we have with the state for this project.
Any comments? Steve?
GR, on the map, it shows the access control line on just the one side of the highway, the airport side of the highway. Is there also a line on the other side of the highway, on the ABC side?
Yes, but I don't believe we're breaking it on that side. This agreement just deals with that piece.
So any time that any access point, well, how about the pedestrian crossing at the traffic light that used to be there? Was there some sort of an access agreement for pedestrians to walk across there?
No, because it was on the state right-of-way and the state maintained that. And since we built this pedestrian undercrossing, it's another governmental body owning infrastructure within the state right-of-way.
Okay, okay.
I have a question regarding just the underpass in general while you're here. Is there any knowledge of people not using the underpass and trying to cross the highway? I mean, that was what we were trying to do with creating this.
Right. We still have a very small percentage of people that cross. A few of them are at the at-grade. We're in the process of right now changing the walkways and the landforms that are right there to help deter that. But overall, the compliance with folks going underneath the underpass is a very high percentage.
Great, thank you. Accept the motion?
I'll move to approve a resolution of the Board of County Commissioners of Pitkin County approving a license agreement with the state of Colorado granting permission to cross the State Highway 82 access control line for the AABC pedestrian tunnel.
Second. And this is set for public hearing on August 13th. Any discussion? All those in favor say aye.
Aye.
Thank you. Next, John Peacock is here to talk about the next two items, I believe.
Yeah,
A
thanks,
couple of
Rob.
acquisitions.
Brian had a meeting in Denver and couldn't be here for these today, but we have actually 3 items in front of you today. I'll cover the first 2, which are acquisitions of condominium units for our affordable housing program. The first is the purchase of a 2-bedroom, 1-bath condominium, 685 square feet. It's located in the Aspen Airport Business Center at 417 Pacific Avenue. We have negotiated a price of $370,000 for this unit, which would be paid out of our housing fund, which is funded by housing impact fees collected at time of development. The unit will be put into our pool of units. We do not deed restrict these units, but we offer them at deed restricted rental prices unless we decide to dispose of these units for sale, in which case we would encumber them where allowed with a permanent deed restriction. But it has been our practice to offer these units as rental units, typically at Category 2 rentals. For the general public, we also take roughly half the units for our own employees, and we balance that out basically as there's demand. Sometimes there's more demand for community units, so we'll push the units there. Sometimes there's more demand on our units, but it's roughly split in half. And so the recommendation of staff is to approve the first reading of this ordinance authorizing purchase of this unit for $370,000. We will bring back the housing matrix analysis for second reading, which is the analysis used to seeing about how the rental streams and expected appreciation value of the properties compare to the price that we're paying.
Very good. I would make a motion to approve the ordinance approving the purchase of Pitkin Park Place Unit 417A for the Pitkin County Employee Housing Inventory and authorizing the chair to execute the necessary documents.
Second. I have one discussion. I think you just mentioned it at the very end there, John, which is that you'll bring back some information. I would kind of request in a month or two times when we settle out of the summer here a little bit, that we look at our entire inventory, kind of have an analysis comparison of what's going on with each one of the units. And I'll say for the public's benefit that, we have been collecting this mitigation money for some time now. It's been building up at the bank to the tune of about $11 million. With a very, very, very low interest rate over the last 5+ years, and putting these dollars to use into our inventory, whether they're for county employee use or for general public use. I think one of the things that we look at, or that I've looked at when the city or various people have done projects, they look at these dollar subsidy amounts per unit. So I think one of the things to understand with these units is that it's now an asset to the county. We put it into our asset management portfolio, so it's not dollars that are going away. In most or all cases, they are revenue generating, so there is a rent being charged to these, so that's also an asset. So the subsidy is actually per unit much less than these numbers that you're seeing here. Because once you take out the fact that we are increasing our assets as the county and we are creating an annuity revenue flow on rent, it won't always be rented, but there is an annuity revenue flow, and you back that out, not to mention the economic value of having somebody in our community working close by, those sorts of things. There's added value to that, which can't exactly be quantified, but does have an added value. So the subsidy per unit is far below the amount, and in some cases the subsidy, I would even argue, is zero, because the value that we're getting is more. So we're creating deed restricted houses with zero subsidy to it. And so those are some of the things that I'd like to discuss in a brief work session down the road with our entire inventory, because I think it's important that the public knows those aspects of this program. So, Steve?
I'd be curious to know who's living in the different units that the county has purchased, just to see how the impact it's had on the employees and what it's done to their commute times, or has it made it possible for them to do their job better, or all those sorts of questions. And that's kind of related to the impact of the units that we bought. How is that impacting the human beings involved in it?
Maybe Laura can be here for that.
Yeah, we can give some anecdotal information along those lines with the number.
George?
John, with all of these purchases for workforce housing, are they all contingent on appraisals coming in?
They are all contingent on appraisals, yes.
We have a first and a second, I believe, already. Any further discussion? All those in favor say aye. Aye. And very similar item.
Very similar item. This is authorization to move forward with purchase of Unit 1216, Hunter Creek condominium located at 1216 Vine Street in Aspen. This is a one-bedroom, one-bath unit, 581 square feet. The purchase price here is $420. Again, this is a location closer to the Aspen core. We tend to see a little bit higher per square footage price. One of the elements that's unique to this property is there are covenants here where you cannot deed restrict the property. So in this case, the county would be offering it either as a affordable rental to one of its own employees or community employee, depending on where the demand is. But if there is a future sale of the unit, it would not be encumbered with a deed restriction. Those dollars would have to come back into the housing fund.
Rachel?
Mr. Chair, I am going to step away to the table because I live at Hunter Creek condominiums, and I apologize for not noting that before John started his presentation. That's okay. I didn't think about it.
At any rate, similar to the last unit that we discussed, this falls within the price range, Rob, as you were describing, that you'll see on the housing matrix. Comes close to covering itself with a combination of asset appreciation as well as cash flow off of the rental incomes. And we will bring that matrix back to you for second reading.
Any questions, discussion, motion?
I would make a motion to approve the purchase of Unit 1216 Hunter Creek condominiums.
We have a second. Second, first and second. Any discussion? All those in favor say aye. Aye. Thank you, John. Is Chris? Yeah, get Rachel. And is Chris coming down for this?
Ellen's handling this.
Oh.
Oh, yeah.
She's behind the pillar. Next on our agenda is a resolution of the Board of County Commissioners, Pickens County, Colorado, approving and authorizing the execution of a memorandum of understanding between the Board of County Commissioners, Pickens County, Colorado, and the Bureau of Land Management.
Thank you. I am Ellen Sassano, the County Long Range Planner, and I am sitting in for Chris Selden, who I believe is out of town today. The MOU in your packet allows Pickens County to function as a cooperating agency with the Bureau of Land Management in the development of an environmental impact statement that will review 20 or so federal oil and gas leases that were issued in the Thompson Divide area. At least that's our area of interest. The benefit of working cooperatively with BLM is that it gives us a seat at the table, allows us to provide some specific input information in the development of the EIS. It also allows us to review preliminary drafts of the EIS before they're published on the Federal Register and have some input there. The MOU document is a standard form for the Bureau of Land Management. It's typically not negotiable, but Chris has spent some time ironing out a few minor details, and BLM has agreed to make a few changes. to the draft in your packet, and having reviewed it, Chris has recommended, the county attorney's office is recommending approval of the reso to execute the MOU in your packet with second readings set for August 13th and public hearing. So I'd be glad to take questions.
Questions of staff or Steve?
Comment. I would approve of doing this MOU. I think it's really great that we get a seat at the table with them. And just for the public's information, it talks about us as being a cooperating agency, and that kind of implies just the wording that we are cooperating with the BLM, but it does not obligate us to agree with them on decisions. And let's see, quoting the words exactly, it says nothing in this MOU shall be deemed to bind either party to accept or support the position of the other, nor shall anything herein be deemed to waive Pitkin County's right to protest, object to, appeal, or otherwise challenge the EIS. So it gets us a seat at the table so we can help give input into the process, but we can still protest the final outcome without any problem. I think that's important.
That's a great clarification, and though we do get to provide comments prior to publication of any draft on the Federal Register, once it's been published, Pitkin County will still provide comments as a local agency once the draft's been published. So yeah, we get to comment and remain impartial. Right? That's throughout.
George?
Ellen, I'm just curious, because this reso gives us the ability to be a cooperating agency, specifically just on the leases that are in question in the Thompson Divide, or is it going to go beyond that? Because my question then is, why would Rio Blanco County be involved in Meeker? I thought they were in a totally different district when we did the resource management plan as well.
You know, I believe that the EIS is actually going to be reviewing roughly 65 federal oil and gas leases. Our particular interest, at least most specific interest, is for those 20 that are in the Thompson Divide area. But all of those other agencies are involved because this is the EIS will cover more than just those 20 leases.
All right, thank you.
It's my understanding.
Rachel?
Thank you. I'm fully supportive of this. You know, your traditional role is to offer scoping comments, wait till a draft comes out, offer some more comments, wait till the record of decision comes out, and either protest or not. And so this offers far greater insight and opportunity to influence the decision via the testimony and information we can bring at the time. I was just kind of wondering if we need to formally designate who our person will be, and if so, when would we as a board have that discussion?
There is actually in your packet Appendix A to the Memorandum of Understanding identifies a contact person and representative for both agencies,
Okay.
including BLM and Pitkin County. And based on the direction that I believe Chris received from you earlier, I will be the point of contact, and Chris will be the representative for the county, and we both
Will be active.
will be active in the meetings.
Okay, I just want to have that on the record. Thank you all. Would you accept the motion?
Yes.
I would move to approve the resolution authorizing the execution of a memorandum of understanding between the Board of County Commissioners of Pitkin County, Colorado, and the Bureau of Land Management.
Second.
The first and a second, and this is set for public hearing August 13th. Any discussion? All those in favor say aye. Aye.
Thank you.
Thank you.
Thank you.
Next is ordinance of the Board of County Commissioners, Pickens County, approving the purchase of the Scott Mill property.
Stotts.
I'm sorry, Scott's. Stotts.
Kind of like Mott's
Yeah.
applesauce.
Stotts Mill.
Thanks, Rob. I'll be filling in for Brian again. This is a little bit different kind of purchase than what we've recently been making with our affordable housing funds, and represents direction given by the board, I think in last year's budget and the previous year's budget relative to the housing funds, to look for opportunities to participate in a larger development project. And so staff has been looking at various opportunities along those lines, and this is our first proposed purchase as a land banking option for a future development. And we have approximately 1.5 acres that we're looking at in Basalt. And just to orient you, I know the screen is still warming up. This is Basalt High School here. This is the Rio Grande Trail running this way. This is Southside Drive. The parcel that we're looking at is bordered here by the irrigation canal, runs down to approximately here and comes across, a little bit farther down actually. The adjacent parcel here is one that looks like it will come to the town of Basalt as part of a future annexation agreement, so it'd be adjacent to that. On the back side, we have open space property. We believe that this property currently is not annexed into Basalt. It's within Pickens County, but it is within Basalt's urban growth boundary. In discussions with Basalt staff, it appears to be appropriate for development of multifamily housing, similar to what you find a little bit lower down on Southside Drive. We've done some preliminary layouts, and it looks like under that similar kind of development pattern that there would be 24 potential multifamily units, more townhome kind of units that could be developed on this property. And so at this point, what we are proposing, this is a good location. It has good access, again, to downtown Basalt, raft of bus stops. It's obviously adjacent to the school and also adjacent to the Rio Grande Trail. So at this point, what we propose is purchasing this property, then budgeting housing funds in upcoming years to do some of the due diligence work, development alternatives and such for the board to consider. This property is being purchased from Ski-Co. They had purchased it at the height for close to $3 million. We have a proposed contract at $1.4 million subject to appraisal.
I have a question I'll start off with. Under the key discussion items, it says, does the BOCC agree with the purchase of this property, understanding the partnership idea with the Aspen Ski Company? What encumbrance is the idea, or is it just an idea?
There's not an encumbrance so much as the county owns the property outright. And thank you for pointing that out. There is an initial discussion with the ski company that they would like to partner on development and then ongoing ownership and management of the property if we're so inclined.
But not ongoing ownership, because we would own the property.
We would own the property, but ownership of units.
Of the development.
And also looking at maybe, because one of the goals of the county has been to try and get into partnerships where we have another capable entity to manage the properties long-term, because we haven't hired any housing staff or created a housing program within the county. We can rely on APSHA for some of that function, but we still have a property management function. And so the ski company has expressed interest in partnering with us on development of the project and management of the project. We are not obligated to do that under this purchase agreement. We think, though, that may be a good idea, and that is a potential partnership that we explore going into the future. I think from SKICO's perspective, looking at developing housing appropriate for their management and mid-management level employees is in their interest, and that would be appropriate also for us, and to maybe offer a slightly higher category to the public, given that these units will probably be a little bit larger, for example, than the condos and such that you just saw.
Thanks for the clarification. Further questions? Rachel?
Well, again, just to clarify further, is should we go forward and own the property, there are great potentials for a partnership with the Aspen Skiing Company, but we could, I would imagine, also put out an RFP for other partners and verify and make a selection at that time. This is not a contract. We're not entering into a contract with the ski company.
This is a straight-up purchase contract at the ski company, and what we wanted you to be aware of is we've started discussions about the possibility of a partnership and joint ownership and a future partnership, but we felt like this was a good price to begin land banking, and if a partnership there were not to work out, then we have the land and can pursue a project on our own or with another partner.
Okay. And just two other bits of information for the public. We are purchasing the property from the ski company,
That's correct.
and do we know their prior purchase price before the economy
It was close to
crashed?
$3 million. I don't have that right in front of me. I think it was just under $3 million.
Okay, thank you.
Yeah.
George?
Just a comment, with all these three resolutions before us today, three really different types of housing opportunities throughout the valley from Basalt to Aspen. So it offers choices, which is great, and I think that's what we want to continue to do is look for value and look for choices where our workforce may wish to live in different types of housing options. So I think this is a good example of the work the staff has done with a professional, a realtor, to find these, to qualify what's the word I want?
Value of
The value of the properties. Thanks, Rachel. So I support this.
Would you accept a motion?
I will.
I would move to approve the ordinance of the Board of County Commissioners of Pickens County approving the purchase of the Stotts Mill property, Southside Drive, Pickens County, for the purpose of developing workforce housing and authorizing the chair to execute the necessary documents.
Second.
Any further discussion? Seeing none, all those in favor say aye.
Aye.
Thank you. Thank you. We're now moving into our consent public hearings, second reading, starting with a resolution for expenditures of funds granted through the Renewable Energy Mitigation Program.
And
I did
Mr. Chair,
see-
this is broken into two resolutions because one includes Hunter Creek condominiums, and I will be removing myself from the table for that first discussion.
Something here earlier.
I'll tell her that we're on. We have been trying to manage our time. Would you like us
Should
to
we,
wait on her?
why don't we take a 10-minute break, stretch our legs a little bit, have her come back and do it with her here. So we'll come back at 1:20.
Great.
1:20?
I'm sorry, 1:30,
1:30, yeah.
1:30, yeah. 1:30, yeah. 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30, 1:30 Welcome back. This is our regular meeting, Board of County Commissioners, Pickens County, Colorado. Today is Wednesday, July 23rd. We are into our consent public hearing, second readings. The first is our Renewable Energy Mitigation Program, and Cindy and Mona are here to present. We've split this up into two resolutions. The first one is regarding Hunter Creek condominiums, and Rachel Richards has got a conflict of interest, so she has excused herself for the first section. And we did discuss this a little bit under the first reading. Is there any questions or comments about this first resolution? I will open the public hearing to this. If there's anybody here wishing to speak on this item, they may do so at this time. Seeing none, I will close the public hearing on this resolution and bring it back to the board for a motion or a discussion.
I would make a motion to approve authorizing the expenditure of funds generated from the Renewable Energy Mitigation Program for Hunter Creek condominiums.
Second.
We have a first and a second. Any discussion? All those in favor say aye. Aye. Opposed? So I'll grab Rachel. I'm grab her, Rob. Next, as well, is a resolution for the distribution of the additional funds under the rent program. And again, we did have this in first reading and did go over it. I did see that there was the change made on the Rocky Mountain Institute to $20,000 approving funds. I don't think there were any other changes in the resolution from the first time that we saw it.
No.
Any discussion or questions on this resolution?
Just a question. Again, the funds from the Renewable Energy Mitigation Program, I think, have been really successful in terms of going towards reducing energy use, encouraging energy efficiency in residential and commercial buildings, as well as use of renewables. So I think it's been successful from that point of view. My question is, and I don't think Pickens County has a energy goal per se. Like the city has a Canary initiative. The state actually has a goal in terms of reducing energy use by 30% by 2020 and using renewables, increasing renewables of 30% by 2020. But has does the county have a goal like that, or is that something we should be working on?
We have a policy.
Yeah.
We have a policy through the land use policy guidelines about energy and use of renewable energy and efficiency and conservation. It's not specific to that 20%, although the board in the past has looked at climate change resolutions that include goals for reduction in energy and greenhouse gas over a period of time, and I believe that was a 2030 goal that we worked with CORE on. Right. So we do have that in place, but we don't have a separate energy resolution that I'm aware of.
Right. And do we have a way to track that climate goal? I mean, we sort of put it out there, 2030 we hope, but as we're moving along, I just wonder whether that's something we should be looking at in terms of more concise goals with a way to track it to see whether we're actually achieving those goals.
What we had as a baseline a while back, and I can't remember the year, was a study that the city had done that included Pickens County. And we, I think we participated in that. And that study has been updated and renewed, and we need to get a hold of the study to bring back to you and look at some of those measurements. But I think we could do a better job pulling that together for the county as well.
Yeah, that may be something for a future board discussion.
Okay, great.
Rachel?
Yeah, I would be happy to have that discussion. But I think that the history is that we let our energy manager go when he moved to another community for a job opportunity, and we did not refill that position. It was an eliminated position. Overall, we tried to merge some of the duties into the county as an organization, and that continues to go forward. But in terms of someone to assist us with county-wide programs, we really have tried to depend on CORE. And so I'd be happy to try to have a discussion on goals, but I think that we need to put more meat behind the goals in terms of money and resources if we're really going to see some effect. And so that's just a comment for going forward. The other thing is, I would note that so many others may have read, but we, as reported by the USA Today, a double scorcher, June joins May with the highest heat records on record for our globe again this year. And so we are just continuing to see the rising climate because of carbon emissions, and I myself, as others would, I'm sure, would like to find a way to take greater action and make that more of a priority within our spending and our organization towards our sustainability goals. So,
I would probably, I don't know if I'd be presumptuous in maybe offering that we could work with Cindy and potentially come back with a recommendation. I mean, Cindy and I were having a conversation about another energy using activity in the county that might potentially have some mitigation opportunities. But we have some data. Anyway, the bottom line is CORE, we'd be happy to come back to you and maybe make a recommendation about how you could amp that up. I'm sure you all have plenty of ideas, or we'd love to work with you on how we might do that. But yeah, we have all been kind of working away at this, and we have some metrics on some of our achievements, but I think it'd be really great to say, you know, here's the goal, how are we going to hit it, and what do we need to do to go after it and make that happen. So,
thank you.
And Mona has some pretty impressive goal, I mean, matrix. I don't know if you wanted to share that. Did the board ask for that the last time?
we had presented some numbers at our first presentation when we talked about the achievements of Energy Smart and what we did, and Steve had asked for some numbers in terms of acreage, because sometimes pounds of carbon that's eliminated or kilowatt hours or BTUs are not exactly as comprehensible to the layperson as they are to those of us who are in it every day. So I just sent you yesterday some information about the Energy Smart programs and the achievements for over 3 years, which we were pretty excited about because we were able to sit down and really take a look at it and analyze it. And one of the, I think the upshot was for the overall program in Pitkin County, the amount of carbon that was eliminated by the energy saved over 3 years equates to 1,663 U.S. forest acres. And that's equivalent to the area of Aspen Mountain and Aspen Highlands combined. So if you think of Aspen Highlands and Aspen Highlands, that's about 1,660 some acres. So that is equivalent to that carbon sequestered during those years. So it might not sound like a lot, but actually I think it's pretty impressive for a little program. And we're actually on track to probably exceed that goal this year. The way we're moving. I kind of say that with a little bit of caution because, you know, what happens in the first year may not be repeated in the second half of the year, but the program has just gotten a lot of traction and interest, and people are participating, whether it's on the residential side or the commercial side, so it's pretty cool. But it would be good to have some goals.
George?
Yeah, I think one of our greatest challenges when we talk about energy efficiency and addressing climate change is the challenge we have with transportation. Transportation is probably the greatest use of energy and the greatest expenditure of CO2. And anybody who has to commute that doesn't live on this side of the roundabout understands that we have a parking lot from the Aspen Airport Business Center to the roundabout every day in the morning, and from the Hotel Jerome out to the roundabout every afternoon. And so until we can really address that as a community, we're going to be struggling in terms of addressing some of these larger goals as relates to climate change and energy efficiency.
Can I ask a question?
Yes.
One of those savings that you quoted, does that include the expenditures of the heated driveways and the pools that were permitted by the program?
No, what it includes is the offsets we were able to achieve using those funds. So as your statement last time has stuck in my head about having the gas on, the gas and the brake, and that's what we're doing. Yeah.
So it's actually not savings.
It's the mitigation.
We haven't taken the other side of the equation.
Right, we are mitigating that.
Well, we've allowed the expenditures. What is that achieved in savings? That's the real total. Savings is different from, if you don't count the expenditures, then the savings seem huge.
Further discussion? Is there a motion?
I'll make a motion. I guess it's more generic. I make a motion to approve the authorization of the expenditure of funds generated through the Renewable Energy Mitigation Program for, that's the first one, period, just Renewable Energy Mitigation Program.
And this is the one that includes the Aspen Center for Environmental Studies, the Aspen Community Church, Compass Aspen Community School, the Grid Alternatives, Marble Distilling Company, Picken County Library, Rocky Mountain Institute, and the town of Snowmass Village.
Second.
We have a first and a second. I will open the public hearing. Anybody wishing to speak on this may do so at this time. Seeing none, I will close the public hearing. Any further discussion? All those in favor say, Steve?
You listed the groups that were giving money for. Also listed in the resolution, there are programs supported by CORE, and I think those should be listed for the benefit of the public watching. Community grants for $75,000. Design assistance grants for $61,000. Low to moderate income grant program, $100,000. Big buildings efficiency challenge, $80,000. Energy Smart program rebates, $375,000. Randy Udall Energy Pioneer grants, $619,000. And monitoring and educational kiosks for EV systems, $30,000. So CORE does a lot of different things, and it's putting the money to good use.
Good comment, Steve.
Any further discussion? I'll call the question. All those in favor say aye.
Aye.
Opposed?
There we go. Thank you.
Thank you.
Thank you.
Thank you.
Next is a settlement agreement with CD Holdings, second reading. And John Ely went through this application with some maps last time on a small sliver of parcel in the Aspen area.
That's correct, Rob. It's a singularly slender piece of property, about 160 feet long by 8 feet wide. It's located just behind the Aspen Gardens, Ice Gardens, and it is right on the edge of the Aspen town site. And the exact location of the town site boundary is what gives rise to the dispute over this slip of land. The ordinance that is before the board for second reading and proposed for adoption would authorize a settlement of litigation that is a consequence of that survey dispute, as well as realize for the county $200,000 into the county's general fund for the county's conveyance of any interest it might hold in this particular property. The property itself was created through a subdivision exemption plat that was approved and and recorded after board action in 1993. It described this property in such a particular fashion because of this potential for a survey dispute. A plat note at that time was recorded against the property, providing that it could only be owned by the adjoining property owners in the city of Aspen or by the county itself. The conveyance would send a portion of this Tract C to adjoining properties, which is Aspen City Block 54, lots K through O, and that is the conveyance. The litigation dispute arises by a lawsuit that was filed by the current owners of that city property against the surveyors and the grantors of that property to the current owner. The county was brought into that litigation by necessity because we claim an interest in that particular property. Nothing has changed between the first reading and this second hearing. I would ask the board to accept and approve the ordinance.
Any questions of staff? This is a public hearing. I'll open the public hearing on this item. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing, bring it back to the board for discussion or a motion. Steve?
I think it's terrific that we finally have settled this dispute that's been going on, and it must be a tremendous relief for the 3 landowners involved, and to have the thing finally resolved and to avoid having going to court over and that sort of thing. So I'm totally in favor of this transaction. Would you accept a motion?
Yes, I would, please. Thank you.
I move to approve an ordinance of the Board of County Commissioners authorizing a settlement agreement in connection with CD Holdings LLC and the conveyance of property to CD Holdings LLC.
Second.
First and a second, any discussion? Seeing none, all those in favor say aye.
Aye.
Next is a confirmatory reading of an emergency ordinance establishing a temporary moratorium prohibiting the issuance of any and all permits that would allow for structures that would violate the use and restrictions of the rural remote district.
Okay, thanks. Mike Kramer with Pickens County Planning Staff. And as you said, Rob, this is the confirmatory reading of this moratorium. On June 18th, last month, the board adopted a moratorium that would restrict any types of structures that would violate the dimensional standards in our rural and remote zone district. And as you know, rural and remote is limited to the high country areas of our county. We've all seen maps of them. The purpose of this moratorium is to allow 9 months for county staff to develop potential legislation to recraft our code to more adequately address special events, temporary commercial uses, and potential structures that would be used in association with those temporary commercial uses and special events. If you remember, there were 3 exemptions that the board adopted from this moratorium. One was half of the existing square footage that's allowed in the rural and remote zone district. The second was for any structures associated with a special event or temporary commercial use application. And then the third was, if you remember, John Wilcox was with us at that meeting, and he specifically requested an exemption from the moratorium for a wedding that he's having on June 28th in a property that's zoned rural and remote up Castle Creek Road. Staff is looking for the board to confirm the ordinance, and I can hopefully answer any questions if you have them.
Any questions of staff? Rachel?
I'll make a motion after the public hearing.
Yeah, this is a public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing.
I would make a motion to approve the emergency ordinance establishing a temporary moratorium prohibiting the issuance of any and all permits that would allow for structures that would violate the use and dimension restrictions of the rural remote zone district.
Second.
Any comments? I will make a comment, and I just want to express my understanding and desire to have the second exemption in there, that any structures associated with an application for a special event or temporary commercial use permit is exempt from this, and in the sense that if somebody does want on a property in rural remote to have a wedding and file a special event permit and go through the process, if it goes through an administrative process and gets approval, great. If the administrative process kicks it to the board for us to approve it, that way we can control travel plans, we can control notices, we can control mitigation aspects to it. We're not saying that you can't put a larger tent on your area in rural and remote. We're saying that if you do it, please do it in a process that we can take proper steps to inform neighbors and do various things and make sure that it's appropriate for that area. Any other discussion? Seeing none, I'll call the question. All those in favor say aye.
Aye.
Thank you. The next item is a GSS Property LLC site plan takings determination to be continued to 9/24/14. This is a public hearing. Anybody wishing to make public comment on this item may do so at this time. Seeing none, I will close the public hearing on this item and take a motion for continuation.
So moved to continue this item to September 24th, 2014.
Second?
First and second, any discussion? Seeing none, all those in favor say aye.
Aye.
Next is our land use code amendments. Suzanne Wolf is here to present.
I'm here, and even though it says first reading on the top line of my memo, it's really second reading, now that I'm looking at that. So this is second reading and the public hearing on the various code amendments that you looked at last time. There were only a couple of minor changes made of that meeting that I put 2 bullets on the front page related to the TDRs for limited development conservation parcels going to 1 per 35 acres. And clarifying some language regarding if you were reducing your floor area, that you could get a TDR if you reduced from 5750 to 3250. Those were the only real language changes. There were a few other things we made note of for our future code amendments list, our ever-growing future code amendments list, but I think that was it in terms of changes to the ordinance at this time. Oh, and Steve did give me his notes from the last meeting, and I did do a thorough reread and comb through to make sure that all of the red lines that everything was adding up to end up with complete sentences. So I did find a few things there that got cleaned up. So.
Any questions of staff? I'm sorry, Steve?
Suzanne, I appreciate the fact that you went through everything with a fine-tooth comb. I found
You found it.
2 number 4s that weren't struck out, so it would have read 42 or something like that.
I swear they're gremlins when I read
But the whole thing,
this.
I actually read through all the different changes, and it's all very readable and totally makes sense now. So I appreciate the effort you put into that.
Well, thanks for your catches. Okay.
Any further questions or comments, staff?
Actually, I do have.
Yeah.
Reading through the parts, and especially the parts about the TDRs, there were a couple of things that I would like to discuss in the future, perhaps at a work session. And one is on pages 39 and 47, it talks about criteria for receiving sites for TDRs. And in light of the discussion we had about the Celestial hearing, it seems to me that we could be, there are a lot of different criteria that could be considered in whether a site is appropriate for being a TDR receiver site, including such things as the visual impact on the neighbors and off the road, and whether the site is a constrained site by some physical characteristics, whether the additional square footage is being put underground or above ground, which would add to the mass of it, and so on. Just lots of different considerations. So I would like to talk about that in the future, and I realize we can't make those changes today because they're like substantial changes to it. It would have to go back to P&Z and everything. And the second thing I would like to talk about, I feel like fractional TDR should be allowed for on the receiving site end of it. In reading through it, I felt like all of the sending site criteria and the guidelines were all where they all sounded reasonable to me. But having fractional TDRs for the people purchasing them for their house, I think should be considered, and this would be for a further discussion, thought for staff to look at it and then discussion by us. But my reason for that, a lot of people don't want to build an extra 2,500 square feet on their house. And yet that's their only option, to buy a whole TDR. If they could buy a half TDR in order to build 1,250 additional square feet, or if they could perhaps buy a quarter of a TDR and only build 600 and some odd square feet on their house, I think a lot of people would take that option up because they maybe don't have the money or don't want to spend the money to buy a whole TDR, and they don't really want 2,500 square feet. But that would stimulate the market for TDRs if we did that, and it would give people more options besides just feeling like they have to do the whole 2,500 square feet.
Rachel?
Yeah, I think that your first suggestion of developing greater criteria or consideration points for landing sites is appropriate. And I'm open to a discussion about fractional TDRs as well. But, my interest has actually been going in a different direction, Steve, and that is that, perhaps if someone is going from 5,750 up to 13 or 15,000, that additional TDR purchases are worth less to them as opposed to the full 2,500. And I know that in the past when we have discussed or looked at the idea of fractional TDRs, it does really start to be a tracking nightmare. Has all of one been extinguished or not, and the different ownerships and how do they use it. And I think that has an ability to kind of move us to saying that 5,750 doesn't really mean anything, and that for a very small extra amount of money, splitting a TDR into fifths with somebody else, our basic home size will start to be 6,200 or 6,700. And so I would have concerns. I'm open to the discussion, but I think there's really a 360 view is required.
And I'll just add one point to that too, and then Michael, I'll go to you. That one other argument on that too, because I've brought it up a couple of times in the last 4 years, that if somebody has to buy a full TDR, a lot of time they feel obligated to maximize the value of that purchase. So they build out the full amount when they don't really need it. So, that's an opposite argument. So it's a discussion. I think it's a discussion worth happening. Michael?
But yeah, I think we can have the discussion. It was discussed at the time of the code change in 2006 and rejected. That's the history of it. It's not that people haven't considered it. P&Z considered it, and the board considered it and rejected it.
Any further discussion on the land use code amendments, various sections. This is a did I do the public hearing on this already? No, do it again, just in case. This is a public hearing. Anybody wishing to speak on this item may do so at this time. I did it already? Anybody wishing to speak on this item may do so at this time. Seeing none, I'll close the public hearing on this item and bring it back to the board for a discussion or a motion. Steve?
I would move to approve an ordinance of the Board of County Commissioners of Pickens County amending Title 8 of the Pickens County Code, 2006 Land Use Code for various land use code amendments to clarify language.
Second.
First and a second, any discussion? All those in favor say aye. Aye. Next is the Aspen Valley Ranch clarification. Thank you.
Too small. Yeah, let's see if we just do, I think it's better if we do one at a time, yeah. Okay. All right. We're back. For one clarification, there was a lot of discussion last time about providing access for physically challenged people to still be able to use this, and we managed to walk away with differing understandings of where you all envisioned that taking place. So here we are. And hang on, let me get clear on the two different pieces you've got here. Maybe I'll let Glenn walk through the two different. I'll give you my short version and I'll let Glenn walk you through his graphics. How about that? Staff's understanding when we left was that the physically challenged trail would basically be along the road of Aspen Valley Ranch Road. Actually, I think if I go to the bottom one, that shows what I'm. So basically, where you turn in, and right now where there's the gatehouse, they would be able to proceed up the road through the property and up to the historic buildings and up to the work cook parcel. The applicants went away with an understanding that the new trail that was being constructed along the toe of the slope, which is going to be at a minimal grade, before it starts to climb the hill, would be a way that people would access, the physically challenged would access. It is accessed from the parking area on Upper River Road, whereas there is no parking where you turn into the ranch at the main entrance. And so then, again, I said I'd let Glenn use his graphics, but that would be this upper option where you would use the new trail until the trail started to climb the hill, and then they would cut out to the road and use the road for the rest of it. Our two different understandings of what we thought. So we're back to get your position on that so we can finalize the resolution.
Michael and then Rachel.
Susan, did you review the hearing? Did you look at the hearing again?
I did not go back and listen to everything. I think when we talked, staff thought we were clear on what our understanding was, and the applicant thought they were very clear on something totally different. I don't know if Glenn went back through and listened to everything. I did not.
Rachel?
I was going to ask a similar question. Did you review the minutes? Was there clear or ambiguous direction in the minutes?
I mean, I had the minutes. I don't think it was clear there. You know, again, I think everybody walked away thinking they knew what we were talking about, and until I put the language into the draft resolution before I sent it to Glenn, saying this is where I thought it was, and he said, oh, that wasn't our understanding. So I don't think there was clear direction that went into the minutes.
I'll start by saying that I like this better, but I don't think it was the interpretation of the board. I think the other one was the interpretation of the board, because there was discussion about the gatekeeper, which is now here, and checking in with that individual, and then there was discussion that that gatekeeper wasn't always going to be there, that was somewhat temporary. But I'm happy with this if this is reasonable access for someone who has, not handicapped, because that wasn't my interpretation, but who is somewhat physically impaired and is not going to walk up a big hill and wants to go up on a flatter element. So I'll say I'm happy with this, but I don't think that was what we were discussing, mainly because I do recall a discussion about the gatekeeper, and that gatekeeper is down here. So I think it's pretty clear that we were talking about the other one. But like I said, I'm happy with this if the rest of the board is. George?
Yeah, I agree with you, Rob, in terms of what I recall, that we were using the access to the driveway. We had a prolonged discussion about gatekeepers and enforcement, and we also, Brooke brought up the point that at times they may be haying, and so there may be tractors and vehicles, so to let people who maybe wanted to access that drive at that point may not be the best time to do it. So we had all these issues, but I believe that we came down to the driveway as the access because it was flat, it was level, it didn't have wasn't a trail, so it made it easy for someone to basically just go for a short stroll, which is pretty much all that is. And understanding that there's not a parking lot there, they would have to use the other parking lot, so they'd have to go across the road to get to that point. But that was what I believe I had voted for.
Michael?
Yeah, I don't know why there's any confusion. There was no, I cannot recall talking about anything, and I brought up the subject, talking about connecting it to a new trail. What I talked about was the driveway to the ranch. Period. This is, as Rob said, this is an interesting proposal, but it wasn't discussed at all. Not in any form.
So, Rachel?
Well, let me ask a clarifying question of our attorney and our staff. Is there, because I agree with Michael and George, I remember the gatehouse discussion pretty pivotal to when it would be safe for people to use the road or not. And there certainly was discussion of this, it's not necessarily a Disabled with Americans Act standard as much as perhaps someone with their baby carriage and 2 kids in tow weren't going to push that baby carriage up the hillside. But what I'm wondering is what would be our discretion to potentially consider this different alignment for what I see is the challenge of the parking lot and drop-off access. And if the grade from the parking lot to the connection with the dotted line was going to be smooth, walkable, and a very low grade, that might actually be a better long-term alternative. Because I'm thinking of folks needing to walk down the road, and well, the driveway is kind of flat once you get up on the mesa, it's not flat as that entryway. You know, that's a pretty good little grade when you're going up the hill and getting on top. And it seems that the parking lot wouldn't quite have those same grade challenges from getting to the parking lot over to the trail. And I kind of say that as someone who's pulled a groin muscle, has been hobbling everywhere and hobbled around during that site visit as well. You know, that is a little bit of an uphill coming up the driveway.
So John Ely, protocol question. I think the board is reflecting that they were pretty clear on what the application was and what was approved. In moving forward without the proper kind of public hearings and notice and change to that application as what was represented in that meeting, does the applicant now, I mean, like I said, I would be in favor of this if the applicant is in favor of it, but does it have to come through a new application process? How does that have to happen?
Well, the event that we are assembled for today is simply clarification of the board's earlier action, and there doesn't seem to be any dispute at what that was. So that clarifies and puts a bright line on the previous resolution of the board. If the applicant or property owner wants to request a realignment of that trail, then they can always do that, because it would be an amendment to an earlier resolution. My assumption is under the land use code that would be noticed as a public hearing consistent with the last resolution that granted the approval, although I would defer to Suzanne to see if there's some other way to do that, but I believe that's the way it is.
Could it be a minor amendment to a site plan that the staff could sign off on or bring to the board to sign off on?
I think it could.
Although, given that it was set up by the board as such, it would...
I'm just trying to think of...
I don't see an end run around the board being done.
No, I'm just wondering if it could be a site plan amendment that staff, instead of signing off and administratively, it kicks up to us for discussion and final decision, like they do instead of two rounds with P&Z and
oh, I see what you're saying.
two other rounds.
Steve?
My recollection is the same as the rest of you, that our impression was the trail was going to be up the road. There was also discussion about having to have the trail separated from the road right next to it at some point, and that seemed ridiculous to build another trail just for a few people right next to the road, because the road is right there. I'm like you, Rob. This alignment here would be fine with me, with the provision that stretch of trail from the parking lot to the end of Lot 1 might have to be built to a little bit higher standard than the rest of the trail. Starting where the hillside trail part shows, that could easily just be a fairly narrow single track kind of a thing. It's going up at a steeper grade. The part getting to there for a physically challenged person might need to be wider and smoother than the rest of it. And that would be my concern.
And signage here that would say physically challenged individuals with permission previously granted are allowed to take this route with a little map or something.
I don't think that was part of that.
Yeah.
Well, I'm not, we're not changing I think we've already decided on this.
Well, it's just not the language you're suggesting.
That we're not changing anything in the previous hearing. Unfortunately, that ship has sailed. I'm talking about future, I'm in a discussion about future possibilities. So yes, we have not decided on anything. What we've decided on is not this map, but the other map. I think the board was pretty clear in that. And this doesn't require a vote. This is just for clarification. But I'm saying if they do come back with an application, that's something that I would like. And that's one commissioner saying that, not the board saying that. Michael?
So my proposal would be to let the applicant construct the trail. He's heard some of the guidelines we'd like on that trail. Construct the trail, Because actually, that's been one of the real problems for this development, previous development, and the development before that. The trail wasn't defined. The applicant wants a defined trail. Let them construct it. And once it's constructed, we can go on a site visit, go up the driveway, go up the new trail, sort of weigh the things physically by seeing it, and let the applicant come forth with an application that changes their current their application to connect the trail at that point, if it's suitable, if we find it suitable. I would hate to change it now, given 2 lines on a piece of paper, because the nature of it is important to the people who use it. And I would like to see the trail constructed and ready to go before I personally make any changes.
And just to be clear, John Elia said we can't change it now.
Right, no, but
they could bring in an application.
The conditions I would like would to have the trail constructed so I can walk both alternatives and decide at that point whether the alternative that the applicants are proposing, which is essentially this, this is a new proposal, whether that proposal would work for people with this. It well might, but until I walk that trail, I won't know.
Rachel.
Well, I would like to clarify one thing. Until the trail is constructed, the access for the public is the ranch road as it exists today. So we have an underlying ability for the public to use that trail access based on the prior approvals, and until the conditions of the new approval come into play and the trail is constructed, there is public access, and it is what we would currently consider it to be the physically challenged access. And so I think Michael has made an excellent suggestion. I think that there's an opportunity to change the final platting and the final determination of the trail should it be sufficient for those individuals. And they have access today. We're not taking anything away. We'll let our time play out, see what the trail ends up like, and listen to the request then. I can't imagine why that doesn't work. So that would be my direction.
Does the applicant need any clarification, Glenn?
I just have a comment. Thanks for taking the time to do this, because we did walk away with a different impression. So I think what you're saying is a good idea. The trail can be built with an adequate platform for the physically challenged. The grades will be less than 5%. But one thing you should understand is, given our approval, we can build it to that point right there. This little segment right here, from there to there, would have to be done, after you've looked at it.
Because that's the connection that you'd like.
And I'm confident that this is a far better trail experience for all type of people. And one of the things that Tom mentioned is that, if you are handicapped or physically challenged, one of the things that he's observed is people are happier with having the same sort of trail experience that the physically capable people are, rather than being segmented, on an area all by themselves. So we can consider this as a challenge to prepare this trail and move forward with that. Are you comfortable with that, Perry?
Well, I'd just like to make a couple.
For the record?
I wouldn't have insisted.
Brooke, just identify yourself. Sorry, I got to stop people.
Brooke Peterson, manager of the Aspen Valley Ranch holding company that owns the property. I wouldn't have wasted everybody's time if I didn't have an entirely different impression of what you guys agreed to when we had the last meeting. I'm the one that drove Glenn to bring this back to Suzanne. My impression was, and I'm just going to say it, when we had the discussion about the gatekeeper, gatekeeper was not exactly, we talked about that, but we also talked about how we were going to monitor the use of the trail. And gatekeeper was morphed into a discussion about the ranch manager being notified, or people having to contact the ranch manager before they came on the trail. That's my recollection of where that ended up. My other recollection is that when we left here, you guys had approved our alignment of the trail with the addition of this little spur to handle the physically challenged individuals. I mean, with all due respect, you don't have to build a trail to see that the trail experience for anybody is better than walking up the driveway. The first part of the driveway, as Rachel referred to, is about an 8.5% slope. Everything else is at 5% on the new trail. And I, again, I have been out of the realm of dealing with resolutions for a long time, but you adopted a resolution that then has to be signed by the chairman. That to me means that the resolution hasn't been adopted until it's signed. So I believe that you guys could today, if you wanted to, deal with the alignment of the trail, because I firmly believe that we left that meeting with an approval for the trail alignment we wanted, with this a spur to deal with the people who are physically challenged. And I'm sorry, obviously everybody else sitting in your chairs has a different impression than I did, but I wouldn't have wasted my time and all of your time if I didn't think that the alignment, it was just a question that the alignment was not agreed upon, or people had different impressions of the alignment, as opposed to that we were trying to do something totally opposite of what we talked about at the meeting way back when. So.
Well, I understand that there could be some discrepancy as to the understanding. And I wasn't saying, when I said that, to me it was very clear that it was going to be the road. I wasn't trying to say that someone was trying to bring an application back to switch something. But I can only tell you what my opinion was when I left the room, or what my belief is now of what my opinion was when I left the room, which was that it was going to be up the road. And I think that's why this is being brought to us, to kind of clarify what the understanding was of the board at that time. And I think the board has weighed in on that. And then the next question is, John Ely, hearing what you just heard, do you think there is leeway to make some decisions now, or does your previous comments still stand in terms of this has to go through some sort of process?
I appreciate Brooks' comments, as always, but I don't believe we're constituted to make those changes if the board so desired to make them.
Can I ask a question?
Yes, Michael.
So I think we should proceed as we decide. But Glenn, there's a structure on the property that's like a large tank that's elevated. Are you familiar with that?
I'm not.
This is aside from the trail discussion.
Are you familiar with it?
Isn't the historic barn?
No, but on the property there's what looks like a very large tank on legs.
Probably a water tank.
Oh, yeah, that's what it is.
The water tank is dealing with dust control.
Yep.
So that's visible, highly visible. And a lot of people, when you drive, when you sort of crest a hill at West Ranch, you can see this structure. Is that temporary? When is that? How long is that going to be?
It's Tom Newland, Aspen Valley Ranch. It's temporary and part of the construction for the debris flow field. We've been really hitting on dust control seriously over there, and we need that tank to make that happen. I think we go out 3 or 4 times a day and hit the roads.
So that's greatly appreciated. But the tank, is that going to stay for this season? Or is it...
Well, it'll be in place until we get done with all the earth moving activities for sure. So it'll be here probably into next year.
So through the winter.
Now, maybe in the winter we could take it down. I can talk with a contractor about it. And see.
How tall is the structure?
Oh, it goes up about, I would say it's 10, 15 feet tall. What it has is pneumatic legs that bring it up. That way you can get it right into the truck quicker. And then when you're done, it comes down and then you haul it.
Yeah, it's tough to see something like that.
Rachel?
Thank you. Brooke, also with due respect to your remarks, I see the course of action which Michael has described going forward as really being a wash. You're going to be constructing the trail. Current access is the road until that trail is constructed. The board has said that it's open to consider permanently memorializing the change that you believe was already incorporated. So I think we just should proceed. And we'll take a look when the trail's built and memorialize it then as the appropriate handicapped access.
We don't have to take action on this item.
No.
I mean, we can have the board reaffirm that direction. We all agree. Straw poll. Does everyone agree that that's the appropriate direction?
It's a no change.
Yeah.
Okay, thank you.
Or thank you for your time.
Next on our agenda is the Gardner takings determination. The last takings determination was a public hearing. Is this a public hearing when we continue this? No. So I will take a motion to continue this to 8/27/14.
So moved.
We have a first and a Michael as a second. Any discussion? All those in favor say aye.
Aye.
Now we're into open discussion. John, do you have anything for us?
Not at this time.
Does anybody have any additional open discussion? Seeing none, I will take a motion to adjourn our meeting.
So moved.
We have a first and a second. All those in favor say aye.
Aye.
Thank you, everybody.
Thank you. So I know we were talking so quickly.